Hello, everyone. My name is Carla Casas Torres. I am an immigration attorney in Chicago, and my firm is Casas Immigration. Today, I wanted to talk to you about a very important recent Supreme Court decision that was handed down in June of 2018, just a couple months ago. And the name of the case is Pereira versus Sessions. But before I go into more detail about the case, I want to give you a little bit of background regarding immigration court proceedings so that the decision makes more sense. First, when the government wants to start removal proceedings against an individual trying to deport them, the government has to serve that person with what's called a notice to appear. This is the charging document that basically initiates removal proceedings in the immigration court. The notice to appear typically has to include the individual's name, the allegations as to why the government believes a person is removable, and it is supposed to also include the date, time, and location of the immigration court hearing so that the person knows, when and where they're supposed to show up to court. Now, those of us who practice immigration law know that 95% of the time, the notice to appear does not include the time and place of the time and the day of the immigration court hearing. Typically, the person will receive a letter from the immigration court, a notice of hearing later on, letting them know what day they're supposed to appear in immigration court. Another important thing to know is that when a person is in removal proceedings, the government's trying to deport them, there are several forms of immigration relief that the person may be eligible for, depending on the circumstances. But one of the most common ones I see in my practice is called cancellation of removal. And this form of relief is one of the requirements. There are several requirements, but one of the important requirements relevant to this case is that the person must have been residing in the United States for at least either 7 years or 10 years, depending on if the person is a legal permanent resident, then it'll be 7 years. If the person is not, then it's 10 years. Now, another important thing to know is that the moment that the government serves that individual with a notice to appear, then that stops the clock for purposes of the person accumulating more time in the United States. So, for example, an individual who has been living here 9 years and 11 months, the moment they're served with the notice to appear, that stops the clock. So that person will never reach the 10-year mark and will not be eligible to apply for cancellation of removal. And that brings us to the Supreme Court case, Pereira versus Sessions, because that is exactly what happened in that situation. Mr. Pereira made the argument that the notice to appear that the government served him with did not have the date or time of the immigration court hearing. So he argued that it was not a valid notice to appear, and as a result, it did not stop the clock for purposes of his cancellation of removal defense. And fortunately, the Supreme Court actually agreed with him and found that a notice to appear that doesn't contain that important information, the date and time of the hearing, is not a proper notice to appear. It doesn't comply with the law, and as a result, it can't stop the clock basically for that potential defense of cancellation of removal. Now, obviously, this case has had a big effect already in a lot of cases that are currently pending, removal cases that are currently pending in immigration court, but it could also potentially affect cases of individuals who have already been deported. If the person was deported under a notice to appear that did not contain that information, the date and time of the hearing, that individual could potentially file a motion to reopen the case and try to reopen that case in immigration court. In addition, a lot of us attorneys all over the country are also making the argument that any removal proceedings that was initiated by a defective, improper notice to appear that didn't contain the date and time of the hearing must be terminated because the court does not have jurisdiction if it's not a proper notice to appear. A lot of the judges have actually been terminating cases under that argument. Other judges are not signing up for that. So this is an issue that will most likely probably go up to the higher court again and possibly end up in the Supreme Court. But for purposes of right now, what's important for people to know is anyone who is currently in removal proceedings or who has been, removed in the past or deported in the past should contact an immigration attorney as soon as possible, somebody who's experienced with immigration court proceedings, to explore their options and make sure that they are presenting any potential defenses in a timely fashion. In immigration court, if you don't present a defense, you could potentially waive it. So it's very important to present those defenses if you're eligible for them. So I definitely encourage everyone who is in that situation to reach out to an attorney. And also, please share this video with anyone that you think could benefit from this information. If you'd like to contact me regarding a potential case or any other immigration matter, you can reach me at 312-971-7221. You can also email me, Carla@casasimmigration.com, or you can also find me on Facebook as well, Casas Immigration, the name of my firm. Thank you for listening and have a great night.